Hello, 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 everyone. It's Allison Williams here of the Williams Law Group. I want to welcome you to our special broadcast of Moving Families Forward with Williams Law Group. So, as you know, today is Tuesday. We're the day after Memorial Day, and we were closed yesterday for the holiday. I was physically available yesterday, but I figured a lot of you, like a lot of people in my family and my friends, were out and about and enjoying the wonderful holiday, even though it wasn't the best weather. And so as a result, we decided that we would go live tonight instead of yesterday. We also decided that we were going to do a show that was just Q&A and talking about three particular topics: divorce, custody, and domestic violence. So the question is, why would we do that? Why would we not have a guest on the show if we were going to move the show one day forward? And the reason is very simple. It's because we have a lot of followers on our page, and we have a lot of clients, former clients, referral sources, professionals we work with, local community leaders, etc., that know a lot about what we're trying to accomplish with moving families forward, but they don't necessarily know why we have decided what is at the core of our deciding to do the show. So since the show is relatively new, I am going to start by telling you a little bit about that and why we are doing this show. And then we're going to move right into the substance of tonight's show. So, as I've said before on previous broadcasts, Moving Families Forward was really an initiative that I thought up with some members of my team to kind of bring to life the reality of what it is that we are doing here at the Williams Law Group that's different than other family law firms. Because I have the utmost respect for many of our colleagues that practice family law, and some of them are just exceptional attorneys and very capable, as we are very capable in terms of helping people deal with divorce and custody and domestic violence and child abuse and neglect, which is the area that I personally have spent most of my career really innovating in. But one thing that I think is sorely lacking in our profession, and it really is a philosophical view that I have, is that divorce has become this almost rite of passage in our society. That people go through marriage, they go through divorce, and it really is just a negative thing that we experience. And unfortunately, I'm just pausing right now because I have a comment. Somebody is saying that they are not able to see the live stream. So I just want to make sure that everybody can see the live stream. If you would give me some comments to let me know that you can actually see it. Some people are saying they're only seeing a spinning clock. I'm going to refresh the page to make sure that everybody can see me and hear me. So any comments that you can give in that regard. Okay, great. So I'm starting to see some more comments come in. So I'm going to go back to the content I was covering. So a lot of people know about what we do here at the firm. They know that we are a family law firm, and they know that we're passionate about helping families through transitions. But I philosophically have had a problem for a long time with the way in which our society is looking at divorce, and that divorce seems to be almost a inherently negative, destructive process. And of course, we know that people go through a lot of emotions in dissolving a marriage, and it certainly is not something that we would ever say is a happy experience for most people, but it doesn't have to be the end of your life. And the way that we really try to help our clients understand the divorce process is we really want them to understand that this is a new transition, a new phase of their life where they get to craft the rules for themselves. They get to decide where they're going to live and what type of atmosphere they're going to create, how they're going to raise their children, and what type of home that they want, where they want to spend their time, how they want to spend their energy, what they're going to do with their health. A lot of those decisions that become interdependent when you are in a marriage, you oftentimes will lose a sight of your own voice and what it is that you personally want, because you're thinking about the whole, right? And a lot of people lose themselves through the process of marriage, particularly longer term marriages. And that doesn't have to be the case, but it often is the case. And so divorce oftentimes creates friction for people, not just because they are going through the process of reconfiguring themselves, but they are also trying to create a new identity for themselves that's separate and apart from the person that they were once married to. And that oftentimes creates emotional unrest, or what we like to refer to as cognitive dissonance, i.e., that there's a certain thought process that was framed in a certain way, and now the shifting of that is creating some disagreement internally, and you can't quite reconcile the old you and the new you. So I know a lot of people go through this, and we've helped a lot of clients through these issues. But personally, we have also helped people reframe their thoughts around divorce and help them come to a new realization of how divorce can be a positive step forward in their life, if not positive in and of itself. So through that, here at the Williams Law Group, we have what's referred to as a concierge service. And that means that when somebody comes into our office, we don't just talk about how we can legally separate you from your spouse. That is the primary role that you want us to serve. But we also do things like help people create that new life as they're going through the process. And so that new life looks like a lot of different things, right? It looks like creating a new understanding of money. How are your finances going to look now that you're the one solely responsible for them? And what is your health going to look like? How are you going to support yourself emotionally and spiritually? Are you going to have new friends? Are you going to maintain old relationships? Are you going to have to create new healthy relationships, including with your former spouse if you have children with that person? And so a lot of those issues people don't necessarily think about because they're so emotionally unearthed by the process of divorce. And so we start bringing in professionals all throughout the process to really help people with that. And not simply when there's a need, i.e., I've got to sell my house, so I have to get a realtor. You need that person. We try to help you be forward thinking and actually create relationships with professionals as you are going through the process so that you are reconstructing new parts of your life even before you are dismantling or reconstituting the old parts of your life. And so through that process, we have had occasion to deal with a lot of really wonderful professionals that have helped us to help our clients become healthier, happier people at the end of their marital dissolution. So what we thought we would do is we thought we would start working with the local community, bringing to our clients, our referral partners, and people that are local to our area, as well as anyone that happens upon our page, the insights of the various different people that help our clients in the ways that they do. And so we have created this interview process. We call it Moving Families Forward with Williams Law Group. Every Monday at 7 o'clock, we're going to be here. We're going to be talking to a different professional about some area of family life. And it's not just divorce, it's also how you can be happier and healthier in your family, whatever that family looks like. So your family could look like, it could look like two people who are now divorced, who are co-parenting, living in the same neighborhood. It could look like one parent moving across the states, moving across the country because of a job, and now a child is going back and forth between different locations. It could be that you have now remarried, and so you have step children and step parents, parenting, co-parenting as a triad, if you have one married couple and a single, or even as a quad when you have two remarried spouses. And a lot of these issues that people will face in the course of human life are becoming much more commonplace, and there really isn't a resource out there for thinking about how to reformulate your family and be healthier and happier in that process. So that's what we are. We are that resource. We want to be that hub of information. Monday at 7 o'clock, you can come here and hear us and learn about what we offer in terms of services through our providers. And it's not about Williams Law Group. It really is about how we can help the people that we care about the most, who are our clients and people that we serve in this area. So tonight, as I said before, it's just me. We decided to do this show so I could go live and answer some questions that people might have about divorce, custody, and domestic violence. So until I actually start getting questions in, I'm just going to talk a little bit about it, and maybe it'll trigger some thoughts that you have. For those of you that are showing up, I really want to thank you for being here. And if I can't get to your question tonight live on the show, I will do the best that I can. You can always message us through Messenger on the Williams Law Group Facebook page. So I do see some people have started making comments. I want to just acknowledge that we have some people here that have noted that she would rather people. We have, I guess it's Mahaley Stewart. I hope I'm saying your name correctly, noted that she would rather have folks marry than divorce as opposed to having children and bailing out. The marriage commencement is so much easier. And that's definitely true. It's very easy to get married, not so easy to get divorced. So people should really make a wise choice when they are thinking about the process of getting married. So we have another member on our page. This person is signing in as Williams Law Group. So I imagine it's a member of our team. But the question is, how long does it take to get divorced? And that's a great question. So one of the things that I tell people is, they hate the lawyer's answer when we give the lawyer's answer. The lawyer's answer to almost everything is, it depends, right? So I'm not going to give you that generic answer because I know people hate that answer, but I'll give you some general guidance. So we have a governing body in New Jersey called the Administrative Office of the Courts that we refer to as the AOC. And the AOC has a guideline that there should be, with rare exception, no longer than 12 months for any family to get divorced in New Jersey. And that normally entails people that have, a spouse, a house, a child, some retirement assets, and some physical property that has to be divided, right? Any number of things can make that process longer or shorter. So what most people want is they want it to be shorter. Most people want it over with, right? So how do you get it over with? Well, first thing you should think about is when you're going through the process, the more that you can resolve without involving the court system, the more control you have over how long it's going to take. Because even though we can't control the emotions of the other side, the court system has certain benchmarks that they have designed that are supposed to move you from starting the process to getting to the finish line. And if you involve the court system, you have little to no discretion over those court mandated hearings. So you're going to have a case management conference early in the process. That is to set a schedule for discovery or the exchange of information. You are going to have an early settlement panel, and that's where you come to court, have two lawyers give you their thoughts about how your case can be resolved, and you both have to appear, both sides have to appear for that. You're going to have economic mediation where you go to the office of a lawyer, and that lawyer is going to facilitate mediation where you try to compromise your way to a resolution you both can live with. And if that doesn't work, at some point you're going to have a trial. Now, I'm being somewhat abbreviated here for ease of time, but the general process from filing the complaint for divorce until either an uncontested divorce or the commencement of a trial should not take longer than a year. We have shortened that process any number of ways. If you have a general agreement as to what you and your spouse want to do in terms of splitting assets and establishing custody and parenting time for your kids, we can put that into a property settlement agreement, or what we now refer to as a matrimonial settlement agreement. And once you have that agreement, you both can sign off on it. If you have a signed agreement, you can just file the paperwork with the court, get a court date, and go to court and get divorced. It's very difficult to do that. So if you don't have cooperation of both sides. So if you don't have that cooperation, your timing is likely to be longer. And it usually is the emotional entrenchment of both parties that will tend to elongate the process. But that's a general benchmark of what you're looking at in terms of an outer limit. Shortest time period, I've told people, if you really don't have an agreement, but you don't have a lot to fight about, somewhere in the range of 3 to 6 months. So we do have some other questions. Someone has asked the question, how's alimony and child support calculated? So, wow, that is a very, very broad question. So I'm going to try to give you some general guidance about both of those. So first of all, child support is calculated very formulaically. That means that both parties' basic income is going to go into what we refer to as the New Jersey Child Support Guidelines. And there are different software packages to do that. But once you put your income on both sides, I'm going to use my hands as examples, okay? So you're going to have income of husband and wife that go into the calculator, or mom and dad. And then that income is going to be reduced by taxes. And then you're going to have further reductions for mandatory union dues and mandatory pension obligations. And that will then give you what's left will be considered your adjusted gross income. Your adjusted gross income is then going to be used to figure out what proportion of income you both have. So if you're looking at a family that together has $100,000, wife has $60,000, husband has $40,000, you're looking at a 60-40 split on the income. Then ultimately, we take out some additional numbers and we come down to your net income. And from your net income, there is a percentage that is applied to your net income by the calculation. Okay, it's not something that we can just say it's X percent or Y percent like you have in some other jurisdictions like New York. But our guidelines are based on a certain percent based on your income. So the higher your income is, the lower the percentage is that you are expected to use to support your child based on some historical research that's been done to come up with the guidelines. But ultimately, you get your basic child support amount, and then both parties are expected to contribute toward that. The person who has primary custody, who has more time, physical time with the child, is not going to be paying child support, but is going to be essentially paying their proportionate share of the child support by virtue of having that amount not paid out to the other side. Meaning, if it's $100 a week, the person who has 60% of the income and has may have custody of the child, they're not going to be paying the other side 60% of that $100 because they're going to have the child. So we figure out essentially by using our income and having the calculator how much is going into child support. Now, one of the things that we also have in terms of alimony is a very different landscape. So alimony is not based on formulas. Okay, and a lot of different jurisdictions across the country have looked at the idea of using formulas. There are some jurisdictions that use formulas. New Jersey is not one of them. So there is a rule of thumb that some lawyers have used. It is not permissible by our court, our case law, and it's not something that's codified in any type of statute or any type of rule book. But what we normally do is we start by looking at what both parties have the ability to earn. Okay, that's your earning capacity. That is not what you're actually earning. So you can have somebody who is what we refer to as underemployed, meaning they're not earning as much as they should be earning. Maybe the person lost their job recently, which our law treats as temporary. Maybe the person has opted not to maximize their skills in some way because they were planning to get divorced. But we look at what you have the ability to earn, and that becomes your earning capacity. And then we look at the difference between what both parties are at in terms of their earning capacity. So if there is a differential between what one person has the ability to earn versus what the other person has the ability to earn, some amount of that differential is typically going to be transferred from the lower earning spouse to the higher earning spouse based on a series of factors, including how long you were married, what is the need of the person with the lower income, what is the ability to pay of the person of the higher income, and what is the distribution of property between the parties that would help them meet the marital standard of living. So I know that that seems somewhat vague, but generally speaking, we start with a general conception of looking at what your needs are, and then we try to work our way into a number that that can help you. What a lot of lawyers will do, and again, this is not something that our case law supports, but it is something that helps us to give some round figures to our clients, is we will look at a differential of somewhere between 30 to 35% of the difference between the higher earning spouse and the lower earning spouse as the amount that we would say is a good starting point for your alimony. So we know that neither party is going to be able to live exactly the way you lived when you were married, when you're living in two households, but that's a good starting point for us to understand a good round figure of what is the range of appropriate for alimony. And then the number goes up or down based on the actual facts of your case. So I hope that that was able to give you some general guidance. And of course, this answer, as with all answers that I'm giving tonight, are really general guidelines. You really should consult an attorney and get a specific answer to your specific facts and circumstances, and not simply rely upon these ballparks. But these ballparks are just some general ideas to help you get a sense of what's out there. So we have another question. The next question is, what is there a benefit to a mediated divorce, and do I still need an attorney? That's a great question. So mediation, I mentioned it earlier when I was talking about the mandatory steps in the divorce process, but mediation can happen outside of the court system, or it can happen within the court system. So let's talk about what mediation is generally. So the first thing you should understand is that mediation is a process where you are facilitating an agreement that both parties can live with. A mediator is a third party neutral that does not represent the husband or the wife or either of the two parties. And what ultimately happens is the mediator helps both parties figure out what is considered, quote, in the pot, meaning what do you have between you that is entitled and eligible to be distributed between you? Because there can be some property that is not considered a part of the marital pot, such as inheritances and separate property, gifts, things like that. But ultimately, we have to figure out what is available to be shared. And then we have to reach a conclusion as to how to most fairly share it. And a mediator is supposed to help you work your way from where you start to getting closer and closer together to that ultimate agreement. Now, many mediators, not all of them, but many mediators will give you some general thoughts about what the law is in terms of defining things, but they're not really supposed to give you a position on what to do with your case. So, by way of example, a mediator might say to you, in New Jersey, we have active assets and passive assets. Active assets are assets that rise or fall in value based on something that one spouse has done, or perhaps maybe both spouses have done. Passive assets are assets that rise and fall based on market forces. So retirement accounts are typically considered passive assets. Most people are not grossly increasing or decreasing their retirement by virtue of speculating in the marketplace. So passive assets tend to be divided equally between the start of your the relevant time period, which is the start of your marriage, the filing of the marriage certificate, to the filing of the complaint for divorce, which is considered the end of your marriage. You're more likely to get a 50-50 share of an asset that is passive. Active assets, on the other hand, we start looking at your individual contributions. So if one party maybe physically put an annex onto a house which increased its value, maybe that person is going to get a higher proportion instead of 50% of the marital assets. So a mediator might say, let me talk to you about what is active and passive so we can describe the assets and then figure out what assets might not be shared equally. And you two can kind of tell me what you each think is fair to kind of work your way into a settlement. Other mediators are much more progressive in terms of giving out suggestions. And they might say, you two have a long-term marriage, you have a house together, you have retirement assets. These are typically divided equally. And whether or not we agree with that statement, I'm just giving an example of what a mediator might say. But the mediator is really there to give information to both parties, right down the center, shared with both parties, and then both parties can decide for themselves how they want to proceed. And sometimes you have an attorney involved in mediation. Sometimes you'll bring your attorney to mediation and the mediator can give out the general guidance, and your lawyer can either suggest to you to take certain positions or oppose positions from the other side. Or sometimes you'll do it by yourself. And I've had many cases where I will send my client to mediation, and after mediation, they will come back to me with a memorandum of understanding, or also known as an MOU, that the mediator will draft to kind of lay out what the parties have agreed to. But those agreements are subject to agreement of counsel, and counsel will sometimes come in and say, well, generally, I think this is fair and appropriate, but there are some concerns that I have for my client, so I don't necessarily want to finalize it this way. I want to add something or take something away. So another question that we've had, and I want to thank you all again for stopping in and asking questions. These questions are really great. And again, for those of you that are just showing up, this is Moving Families Forward with Williams Law Group. I am Allison Williams. I'm the owner of Williams Law Group, and tonight's show is a Q&A about divorce, custody, and domestic violence. So the next question that we had is about the case information statement. So let's talk about what is the case information statement, or what we refer to as the CIS. So a CIS is required in the state of New Jersey because it is the financial disclosure document that really sets the tone for how your case is going to be decided, meaning it is a document that lays out what is your income, your assets, your liabilities, your debts, your property, and your lifestyle. And lifestyle is comprised of three different schedules that are on the CIS. So we have Schedule A, which is our housing, and that looks at, of course, mortgages, rents, utilities, things like that that are comprising in the household. Then you have your Schedule B. Schedule B looks at your transportation expenses. So, your car, insurances, things like that to facilitate your transportation. And then finally, Schedule C. And Schedule C is where we have the most wiggle room, or where we tend to see people being the most creative with with their numbers. The Schedule C is where we have all of your other expenses, your personal expenses, everything from your food to your medication, to your prescriptions, your vacations, your clothing, everything that is not a housing or transportation expense. So we look at these three schedules, and it comprises what we like to refer to as the marital lifestyle. And the marital lifestyle is the benchmark that we are trying to hit in trying to resolve your case. So that means that we need to figure out first, what is the number? When you add Schedule A, B, and C together, what is the number of net dollars that both parties assert is the amount that they're spending on a month-to-month basis? Because these schedules are identified monthly. How much are they spending on a month-to-month basis that they both will need in order to have a marital lifestyle? And sometimes the parties agree, within some wiggle room, right? We tend to get agreement on what is the mortgage and how much are we paying in homeowners insurance, and how much are we paying on the phone and the cable and the utilities, right? Those things are not usually in dispute. Every once in a while, you'll get somebody who suddenly can't remember that the mortgage payment was $2,000 or $3,000 more, but by and large, you're going to agree on that. But then you start to get wiggle room with things like your Schedule C expenses, because one party might say, "Oh, we ate out at restaurants all the time, and we were spending $200 or $300 a clip, and so that was an extra $1,000 a month in restaurant bill." And the other party might say, "No, no, no. Our food was basically purchased at the grocery store, and we went out maybe once or twice. And when we would go out, we would usually spend $50 between the two of us for ourselves, and maybe we would have one child with us. But we were very frugal in how we spent." And the way that we verify which party is more accurate about the marital lifestyle, in particular those Schedule C expenses, is we start to look at your bank records and your credit card statements. We do that through a process called discovery. And discovery is where you exchange information, in particular, you exchange documents that verify and support the assertions that either or both parties are making in the litigation. So it's very important to have discovery done in the course of a case where the parties are not in agreement on things such as the marital lifestyle, because if you don't get an agreement on that, you can't really settle your case. And I'm talking a lot about settlement. One thing I should say to kind of frame this is, when people get divorced, you have a right to a trial, right? And at some point in time, that right is going to be explained to you by your attorney or even by the court system. But trials are very, very expensive. And that's the reason why a statistical, infinitesimally small number of people actually get divorced by trial. So even if you and your spouse are worlds apart when you start the process of discussing what you're going to do with your assets, your liabilities, custody, parenting time, allocation of debts, sharing of assets, even if you're worlds apart, you're going to ultimately come to a conclusion in between, because trials are very, very expensive. So let me talk to you a little bit about trial. I just want to kind of segue into this because it's something that I think a lot of people would benefit from hearing. So people have asked me before, can you try my case? I want to go full speed ahead, guns blazing. I want to have a trial. And one of the things I tell people all the time is that I absolutely love trying cases. In fact, before I started this law firm, when I was an associate at previous law firms, I used to be in court 4 out of 5 days of the week. And I'd say at least a third of that time was trying cases, meaning somebody was called to the stand, kind of like what you see in Law and Order, and questions are posed to that person. And we have the joy of what I refer to as cross-examination. And I think of it as joy because I love doing it, where you're confronting people with questions in the form of statements and they have to agree or disagree with you. And through that process, you are working them to an agreement with a position that you've asserted that's ultimately supposed to bolster your claim. So that process, that trial process, is fun for lawyers that enjoy the intellectual intrigue of having a trial. But in the family part, having a trial is not just ill advised, it sometimes can be very destructive because, first of all, if you're having a trial, you're typically confronting one party and their witnesses with inconsistent statements, things that things that they may have said that are not true. Perhaps they were exaggerating. Perhaps they were outright lying. Getting all of that into a record tends to stir up a lot of negative emotions. And if people are going to see each other and have to deal with each other after the divorce, in particular, if they have children, creating all of that animosity is rarely healthy for your client, and it certainly is not healthy for the child that's going to be stuck between two angry people. So I really actively encourage people not to go through a trial if they don't have to. But even beyond that, let's assume that you don't have children, and let's say you just have property, and maybe you're trying to figure out support obligations. What's the harm of having a trial? Well, one of the things that is very difficult for people, and it's hard to explain this when people are kind of starting the process, because everybody says, "I don't care what it costs. I want to go in guns blazing." The reality is trials are very, very expensive. So I'll just give you a scenario if I was going to represent someone in a trial, right? I have a team of very talented lawyers here at Williams Law Group, ranging in fees from $225 an hour all the way up to my hourly rate, which is $500 per hour. But using myself as an example, one day of trial is 10 hours minimum of my time, okay? Because even though it may be 8 hours that the court system is open, we've got to travel to and from the courthouse, and then we've got to have a conversation with our client before and after to kind of frame the issues. So at $500 an hour, one day is $5,000, right? And I always tell clients, no matter how much time we actually get of the judge's attention, right? Because the judge could put us on for a full day and only give us an hour because there are so many higher priorities that have a short time period when they are actually allowed to have testimony. So if a restraining order comes in, or a child abuse and neglect case, or an order to show cause, which is an emergent application that has to be heard right away, then you get bumped and you're sitting and waiting on the clock with your lawyer. And so, but you still have to prepare, right? We as lawyers have to be prepared when we go to court. So if I'm preparing, I typically tell my client, whatever the cost is for a day of my time in court, I'm going to spend at least half that amount of time preparing. So half the time preparing, if it's a $5,000 day, it's $2,500 to prepare. So one day of trial for my client is $7,500. And rarely do you have divorce trials that end in less than 7 to 10 days of trial. And it's usually spread out over at least half a year because the court is only going to give you what is available. So you might not get a week of trial all at once. You're much more likely to get a day in June, a day in July, maybe a day in August, maybe 2 days in September. And that process is always going to be stopping and starting and stopping and starting. Meanwhile, your lawyer has to get reacquainted with the facts and who said what at the last time you were there. So if you take 10 days at $7,500 per day for trial and prep, you're talking about $75,000. So I almost always tell clients, unless you are fighting about millions of dollars, it is rarely in your best interest to fight it out at trial. So we try to settle our cases, and that's one thing that that we are staunch advocates of. Now, we can fight to the death if you want to do that. We're certainly prepared to do that, but we always have to consider the client's best interest economically and emotionally when we're advising them about trial. So we have more questions coming in, and for those of you that are just joining us, you're watching Moving Families Forward with Williams Law Group. I am Allison Williams. I am the owner of Williams Law Group. And the format of our show is to have a guest on each week and to talk about various issues that impact the family, either through the divorce process or otherwise. But this week, in honor of Memorial Day, we did take the day off. So we don't have a guest scheduled for tonight, it's just me. And I decided to do a Q&A to give people some value and give them answers to any questions that they might have. So the next question that we have is, what happens after divorce if I'm not happy with my settlement? Maybe we did not take all the expenses associated to our children into account. Is it possible to correct that? So that's another really, really great question. Thank you, Anna, for that. So there's a couple of different ways that we like to talk to people about the divorce judgment, right? Because we call it a final judgment of divorce. But it really is only final to the extent that you have divided property in equitable distribution. Support obligations are based on your contractual claim, right? So you can have factors, particularly regarding support of children, reconsidered or reviewed, I should say, not reconsidered, but reviewed, based on new facts and anything that impacts the best interest of a child. So the general standard that we have for modifying a judgment after a judgment of divorce is that you have to have a change in circumstances. Now that doesn't just mean any old change. And I didn't think about it, or I didn't negotiate it, or I didn't resolve it is not a change. That actually is just something that you didn't advocate for. So that would not be something that a court would normally say, I'll revisit your judgment for. But let's say that you have a child that's growing, and maybe your child has changed their sporting activity, or maybe your child has a medical condition that has just manifested, and you need assistance with getting support for that. Those sorts of things are considered changes, and those would be the sorts of things that a court would always entertain your coming back to review support. But if it's something that you knew of or should have known of in the divorce, you can be forestalled from coming back and asking to have that revisited. So, the whole idea is that when you settle your case, the court is presuming that you have taken into account all of the positives, the negatives. In fact, when you go through an uncontested divorce, the court will, or your attorneys will, actually ask you, did you have the opportunity to ask questions of your attorney? Did you have the opportunity to exchange discovery? Did you get asset information and liability information about your financial circumstances so that you were well informed? Is the information something that through the course of reasonable diligence you would have discovered if you chose to waive discovery, right? I.e., it's not enough to say, I'm choosing not to look into it. Did you choose not to look into it, and was it something that had you looked into, you would have found this economic information that's impacting your desire to come back and revisit it? If you could have found it, the court's probably going to say you're out of luck. But if it was something that you couldn't have found, i.e., your spouse hid assets from you, or your spouse failed to disclose that they had an earning capacity as a result of some additional finances that weren't disclosed. In that situation, you may very well have a claim that you were tricked or defrauded. And if there's fraud, you can always come into court and assert that you were defrauded, and through reasonable diligence, you would have never found that out because you had a spouse that was lying to you. So finality of judgments is one of those things, like, you really have to look into what the facts and circumstances were. And that's something that I always tell people, you absolutely have to consult an attorney about that, because there's a lot of case law dealing with those issues, and they're very, very fact specific. So I'm seeing that we have another question in regards to child custody. Are courts more likely to award custody to mothers than to fathers? Now, I know this is a hot button issue, so I'm going to take a little sip of water so I can be prepared to answer that question. But diving into that question about who gets custody, mom or dad. Of course, mothers say that the courts are stacked in the favor of fathers, and fathers say that the courts are stacked in the favor of mothers. Let me first talk about what custody is and is not, and then we'll answer the question about gender. So there's two different kinds of custody. There's legal custody, which is decision-making power. Who is going to be deciding if little Timmy has surgery, or little Susie goes to parochial school versus public school? Those major health, education, welfare decisions are typically decided by both parents, and we refer to that as joint legal custody. With rare exception, courts are going to award joint legal custody unless you have a parent who's not considered fit. And unfitness is something that's hard to prove unless you have a sobriety problem, a mental health problem, or some other impairment that's impacting that parent's ability to make sound judgments for their child. So that's legal custody. Physical custody is what most people are talking about when they say, I want custody. So physical custody refers to where the child is going to reside most of the time. And that means that the child could have a primary residence with dad. I'm going to use as an example. and see mom on the weekends, or maybe even 2 or 3 days out of the week, depending on what their schedule is. Or the child could have a primary residence with both parents, or what we refer to as shared custody. And we've had more and more arrangements of shared custody. Shared custody is something that's becoming much more popular. And in fact, I will tell you that we just had our annual convention of lawyers, the New Jersey State Bar Convention, down in Atlantic City, that we have in May of every year. And one of the panels was about this topic that's come up in our legislature more and more. There's actually been legislation proposed to have a presumption of shared custody, i.e., we start with 50-50 and we work our way away from it. And a lot of fathers' rights groups have been advocating for that because, in their perspective, and I don't necessarily disagree with it, there has been a tendency on the part of many courts to say, whomever had the child in primary custody before, when the parties were together, right, whoever was primarily responsible for the child, that should be the status quo when we get divorced. And the child should have that consistency of knowing whoever was caring for me before is going to continue after. The problem with that is that a lot of things change in divorce, right? Divorce is already upheaval for children, and children are oftentimes more resilient than we give them credit for. But in particular, when we're trying to safeguard children and make sure that they have as little disruption as possible, that really isn't conceivable that we not have disruption at all when you're going to go from a household where two parties are working in a certain manner. One party may be working long hours and rarely seeing the children because you've decided as a family that one party was going to be a primary wage earner and the other was going to be more available for taking care of the home and or taking care of the children. And now that we're living in separate households, both parties have to be working, and the primary wage earner may have to work less now so that he or she can spend more time with the kids, whereas the lesser wage earner may have to work more now because there's not enough income to go around in two households. If you really don't conceptualize that the children are going to inherently see the primary caregiver less in the course of divorce than they would have when they were living together, then you're almost by default limiting the income and earning capacity of the primary caregiver parent and inherently enslaving the primary wage earner parent, because now that parent is forced to not only work enough to support the previous lifestyle, but has to work even more because the caregiver parent is not working enough. So we're always going to have that balance of how do we shift responsibility onto the lesser earning spouse to work enough and work more, maybe even work smarter, to be able to generate more income to support him or herself, while recognizing what is most important, which is the child's relationship to both parents. So judges struggle with this, and where our law has currently come down is that there is no presumption of shared physical custody, but judges are very, very different. They have very different views on this. There is no norm anymore. Once upon a time, it was mom got the kids and dad got every other weekend. But nowadays, I tell my clients, unless I know who the judge is going in, I can't give you any answer as to what's likely to be the outcome of your custody case. It is very much dependent on what is considered in the, quote, best interest of a child. So when you think about what's in the best interest of a child, think about it from this perspective. You know, best is in the eye of the beholder, but we do have some case law that tells us what we think of as best for a child. So we know that in our custody law, and I'm trying my hardest not to default into citing statutes because that's something that I know that I do that you know people don't necessarily need to go look it up. But the custody statute in New Jersey is NJSA 9:2-4 if you're interested. And the custody statute says that there's a presumption that children benefit from having access to and a relationship with both parents. So again, if you have two parents and neither one of them is deemed unfit, the law is going to presume that your parents are both going to have a relationship with you in order for you as a child to evolve and grow into a healthy young adult. And so starting there, we want to get as much time as possible to the parents. Now, it's difficult for us to get as much time as possible to the parents when you have a situation where the parents may not necessarily get along. So we know that sometimes we're putting children in the middle of quite a contentious situation. You have a situation where the parents, if we don't take a break, right? If we don't say, what's best for this child based on what the parents are going to put the child through, then the child could be in bedlam if we don't stop and take a moment to think about that. Of course, also want to consider where the parents are going to be, because some careers are just more adaptable to having a child spend more time with a parent versus others. If a parent is a police officer, he or she may be working several days of the week and then have several days off. Nurses also have schedules like that. I have quite a few nurses in the family, and that 24/12 shift where you're working 24 hours of one day and 12 hours later in the week, and then the rest of your time is off. Well, that's 36 hours. That's considered full time, but you are much more available in that schedule than if you were a teacher working during the daytime hours and perhaps having to get the child from after school care if you have to stay after and do your lesson plans or things like that. So it really is very fact sensitive as to who's going to be available to the child. But then we also have to consider things like how old is the child, right? Because if you're talking about a 5-year-old, a 5-year-old is going to need much more physical care, i.e., getting the child fed, sitting the child down, doing homework, religious instruction, supervision. You're going to need to be physically there much more than if you have a 15-year-old, because when the children get to the age of puberty and young adolescence, they start pulling away from their parents as they are becoming their own individuals. And so we know that even if you have children who are now young teens, those teens are not necessarily going to be with mom when they're at mom's house or in mom's care. They might be with their friends, they might be with their church youth group, they might be with their neighbors, but they're oftentimes pulling away, not necessarily from the parent, but pulling away from the cocoon of safety that's been created for them. They're really trying to become their own people. So, those were the questions that we've had so far about custody. The question about mothers versus fathers, I've answered it. The one thing I would note as a segue is that we have had a lot of success in getting custody for fathers. So I have a lot of fathers that have come to us, and the fact that men may express their emotions differently than women does not mean that they don't have them. It oftentimes is just as terrifying for a father to not be able to see his son or his daughter as it is for a mother. And a lot of times, I think what happens unfairly is that there's kind of a criticism that arises, and people start to assume that dad was lesser involved. So I will express candidly that I do feel that it is more difficult to advocate for that primary parent dad, or that dad who was getting the kids up, getting them fed, getting them off to school, getting them home from school, doing the homework on the evenings, taking the kid to Little League on the weekends. That dad who is super, super, super involved almost gets reduced in terms of what is presumed to be doing when you have a custody situation. So let's talk a little bit about how custody actually gets litigated. So custody is one of those issues that judges really, really hate to have to decide, because it's not easy to take a child away from a parent. That's what it feels like, right? You feel like your child is being taken away from you because you were used to seeing your child every day, and now you're going to see your child 2, 3, 4, 5 days of the week, whatever it is. It's less than it was before. So I always tell people, think about it from this perspective. If you had to decide as a judge who was going to receive custody, what would you be looking at? And a lot of times the answers that the parents give are, well, who was doing more of the labor? Who put in their time, right? Who was bathing the child? Who was staying with the child when the child was sick? who was taking the kid to all of his or her activities, right? And we think about that from the perspective of who has earned the right of custody. But keep in mind, it's not about what's in the best interest of the person who did more or who's kind of earned their credits for custody. It really is supposed to be what's in the best interest of the child. And so, how do we figure that out? Well, we look at what the child's relationship is to both parents. So, it's not at all uncommon that a child could have been personally and physically cared for by one parent, and yet the other parent is the one with whom they have the better relationship. That other parent could be the parent who's just more emotionally attuned to the child. Or maybe if it's the parent of the same gender as the child, there could be that inherent connectivity of wanting to look up to and model the behavior of the parent who is maybe not the primary caregiver. So there's a lot of different angles that we look to when we're trying to figure out what it is exactly that the court is going to consider for custody. But I always tell people that's not necessarily the issue, right? Sometimes it really is about what the child is experiencing. So, with that, we have another question. Next question is, can grandparents get custody of a child? And that's a very interesting question. You know, in one of the things that we do here at Williams Law Group, and I should note again for anyone who's just joining us now, that you're watching Moving Families Forward with Williams Law Group. I am Allison Williams, the owner of Williams Law Group. And our program is all about bringing resources to our clients and the local community for benefiting their families and moving their families forward. So tonight we're just doing a Q&A with me and those of you that have chosen to stop by. So again, thank you for those of you that are here and watching with us, and please feel free to ask questions throughout the show. But the question that I was just going to answer is, can grandparents get custody of a child? So in our state and in all states, parents have a constitutional right to raise a child. And the only hindrance upon that is when a parent is unfit or where a child's best interest would not be served by virtue of having custody with a parent. So what does that mean, right? It's very difficult to overcome the entitlement of a parent to custody because the court's first concern is going to be what is best for the child. And then assuming that you have one or two fit parents, the next entitlement that the court has to consider is what is the constitutional entitlement of the parent. So if the child's best interest is not served by being with the parent, then the court can overturn or supersede the interest of the parent to have custody. But again, we don't really get to that point unless a parent is deemed unfit. And as I said a little earlier in the show, a parent can be deemed unfit for a lot of different reasons. It could be that a parent is emotionally harmful, is mentally disturbed, has a substance abuse problem, alcoholism, or drug addiction. Any number of issues that would impair the ability of that parent to make wise decisions for the child or even to safely parent the child. And we deal with safe parenting a lot in the area of child abuse and neglect representation. For those of you that have any questions about that, we do have an entire division in our firm, to my knowledge, the largest in the state of New Jersey, dealing with assisting families involved with the child welfare system. The child abuse and neglect area of our firm is represented on our website, and you can find that at www.familylawyersnewjersey.com. That is our general website, and we have both matrimonial divorce and child abuse and neglect divisions of the firm. But if you don't get to that point of parental unfitness, getting a grandparent custody is going to be very hard. Now, one way that we can do it, and it's almost like a multi-step process, is grandparents are not independently entitled to rights to their grandchildren, which I know offends a lot of people. But again, we're starting with the Supreme Court is going to give first priority to what's best for the child and then the constitutional rights of the parents. So if you have an unfit parent, then we're going to look for an appropriate custodian, and it could be a grandparent. But if we don't have unfit parents, we don't even have a right of grandparents to have access to a child if the grandparent's child, i.e. the parent, is objecting. There is a presumption that the parents are entitled to make decisions about who's going to have access to the child, and grandparents can really overcome that only in a couple of situations. So One situation is if a grandparent has been a primary caregiver of a child. In that scenario, we have a grandparent visitation statute that provides that there is a presumption that the child would be harmed by not seeing the grandparent. So that's one way that we can get visitation, which is step one, really, to trying to work our way into custody, unless the parents are completely, impaired to the point where the child is going to be removed from the parent. Another way that grandparents can get access is if they ultimately rise to the level of being what we refer to as a psychological parent. So there's a case, I believe it's from 2000, called VC versus MJB. And that case established a four-prong analysis of the issue of psychological parent. So think about a psychological parent like a person who's basically raised the child and is in all ways the parent to the child except for biological. And we would normally see this in situations where a step parent has been taking over a child's care at the direction of a parent. If that psychological parent or putative psychological parent was financially supporting the child, doing all of the same activities of a parent, they just happen not to be biologically related. In that scenario, we might say that that grandparent rose to the level of psychological parenthood. And if that happened, then they are treated as if they are a parent. So there's any number of limitations on that. I won't go into all the details, but essentially that's how we would get a grandparent custodial rights over a child. We would start with that analysis. So we have another question, and now we're moving on to domestic violence, and we're toward the end of the hour. So if we have additional questions about domestic violence that I didn't get to, I'm certainly willing to stay over. But I will note that the question posed is a restraining order only granted for physical abuse, or can one be issued for mental cruelty? So I want to make sure I understand the question correctly. But first, let me just note that when you're talking about restraining orders are issued in New Jersey pursuant to the Prevention of Domestic Violence Act. And the Prevention of Domestic Violence Act defines who is entitled to get a restraining order against the other. When you're talking about things such as physical abuse or mental cruelty, those are they sound like language that really deals with our child abuse and neglect law. But if you're talking about relationship issues between two people that are either married partners, have a child in common, or in a dating relationship, recently out of a dating relationship, members of a same household, those are the categories of people that would be covered by the Prevention of Domestic Violence Act. So there are lots of different acts that constitute domestic violence in New Jersey. And those acts are all criminal offenses. So I just want to be clear that there's not a separate area of behavior that's not allowed in domestic violence law that is allowed elsewhere. Everything that's prohibited as an act of domestic violence essentially is a crime that is an otherwise covered crime, but it happened to have occurred between two people or more that are covered by the Prevention of Domestic Violence Act. Like I said before, spouses, dating relationship, household members, etc. So some of those acts include things such as a physical assault. That's definitely one of those areas that's covered. We also have harassment is one of the most common, I would say the most common area of domestic violence that's pled. Terroristic threats, false imprisonment, assault, battery, we've talked about those. Those are some of the most common areas. Stalking is another one where you see the act of domestic violence being alleged. But in order to get a restraining order, you have to have two elements. So the first part, once you allege that there's been an act of domestic violence and there's prima facie evidence to support that, you can get a temporary restraining order. But then within 10 days, the Prevention of Domestic Violence Act requires that you have a final restraining order hearing. And that hearing is supposed to address two questions. First, was there a predicate act of domestic violence? And if there was a predicate act of domestic violence, we next ask the question, is there a need for a restraining order to protect the victim from imminent danger or to prevent future acts of domestic violence? So we have situations where, believe it or not, you can have an incident of domestic violence that does not lead to a restraining order. A judge can say, I find that the wife did assault her husband. However, I find that there is not a need for entry of a restraining order under the facts of this circumstance, under the facts and circumstances here. And there could be any number of things that would lead to that. It could be that you don't have an ongoing relationship between the parties. Like you could have had situations where you have a dating relationship, it's a relatively short term relationship. Maybe it's particularly volatile. You have two hotheads that got together, they were dating for a couple of months. Something happened, one assaults the other, and then after that blow up, both parties, decide they don't want anything to do with each other anymore. A judge could find that although there was an assault, which is an act of domestic violence, there is not the need to protect the victim in that scenario because the victim is not going to have any contact with the defendant. Maybe they don't live anywhere near close to each other. They don't have children together. They don't own property together. They have no reason to interact. So that might be a reason why. Now, the very fact that the parties are separating in a relationship is not a basis to say that there's not a need for a restraining order. So we've had some pretty outrageous cases of domestic violence where one comes to mind in particular. It was out of Hudson County where a husband physically assaulted and I believe he raped his wife. And then she sought some refuge and ultimately applied for a restraining order. So, of course, she got the temporary. But at the final restraining order hearing, the court said, although I find that the husband assaulted his wife, I don't find that there's a need for a restraining order because these parties are about to go through a divorce. They're not going to live together anymore. And our appellate division has said, no, you can't really, you can't assume that because the relationship is going to end, that the toxicity of domestic violence that was rampant in the relationship is somehow going to end as well. It really is more intricate than that. You have to look at ongoing psycho dynamics between the parties. So that's a little bit about restraining orders. I know we spent a little less time on that particular issue than custody and divorce, but I hope that you have gotten some value out of the time that we've spent together tonight. I am Allison Williams. You are watching Moving Families Forward with Williams Law Group. I'm the owner of the Williams Law Group. We're located in Short Hills, New Jersey, and we help families all over the state of New Jersey with various different matters, including divorce, child custody, child support, obviously alimony that comes in the course of divorce, support issues, domestic violence issues, grandparent visitation, and child abuse and neglect. So I want to welcome you to come back and join us. We're actually going to be off next week because I'm going to be in Aruba. I won't apologize for being in Aruba, but I will welcome you to come back and join us on June 11th when we're going to have with us Lisa Disculo. Lisa is a parenting coach, and I'm super excited to bring her to our show because she has so much information and value to share with people about how you can have a healthier relationship with your child and deal with some of those behavioral issues, some of which come as a result of divorce, some of which come as a result of hormones, some of which come as a result of life, right? Because kids are not always the easiest to get along with, no matter what's going on in their life. But we welcome Lisa to join us. She's with Parenting Matters, and so she's going to be our next guest on the show. And for those of you that have come with us tonight and come along on this journey of learning about divorce, custody, and domestic violence, again, thank you. If you have a need for our services or help, or just have questions that followed from today, please feel free to reach out to us on our website, www.familylawyersnewjersey.com. where you can get a wealth of free resources on divorce, custody, domestic violence, and child abuse and neglect. I am your host, Allison Williams, and I hope you all have a wonderful evening.